today we've invited our city attorney, David Levin, to come in and just kind of go through a run-through of the quasi-judicial proceedings. The Canal advisory boards are just one of a few that actually have decision-making power, and we want to be sure that we're, because of that, quasi-judicial has certain procedures that need to be followed for due process. So we wanted to bring everybody in and just kind of review that, go over that, so we're all on the same page. So with that, I will turn it over. David Levin's been a city attorney, if you haven't met him, since 2005.
Yeah.
With iCard and Merrill.
When do I get my gold watch?
Yeah, ask.
Yeah, okay. So I'm the guy that the city would turn to defend any challenge of a decision that was made with respect to some of the special permits and decisions that you make as part of your regular operations. And fortunately, since I've been here, I don't recall a single instance when I've been called to go into court to defend an activity or a decision of one of the two boards, and that's a good thing. But we see that citizens are becoming much more litigious these days, and hopefully we can keep that track record the same. But I think that we would be being overly optimistic to suggest that some disgruntled neighbor or some disgruntled applicant will not ultimately take the case forward to challenge the circuit court. As you know, a decision of this board is appealable to the city council, but nevertheless, when it gets to the city council, we want to make sure that the city council has a decent record from this board, and some procedural or due process violation wasn't caused that would then snowball to a problem relating to the city council. So it was suggested, because I don't think I've ever presented a talk to this board in the past regarding your procedures, and so it was suggested that maybe this would be a good opportunity to do so, and so this very short presentation has been prepared, and I'll be happy to answer any questions after I go through the slides. Not very many. I think you each got a copy of one, and hopefully by the time we're done here, there'll be a little bit better understanding of the distinction between quasi-judicial and the legislative functions that you perform. And so when we talk about the legislative functions, I think the easiest way to kind of describe that is recently you all had input to the modifications of Chapter 6, which is the city's ordinance as it relates to the docks and the canals and what have you. And when you get to make a legislative decision, basically the courts are very deferential with respect to the decisions that you make as to what should go into the text of an ordinance law. And the courts will not even look at what the motivation of the legislative body would be with respect to the words that they chose to put into an ordinance, and the courts will not rewrite the ordinance as to what they think you should have said or would have meant. And so your legislative duties are pretty safe from any type of judicial challenge. But there are a number of decisions that you make that are classified as quasi-judicial, meaning that you sit essentially as a judge, just as a judge in a court would sit, and are required to base your decision-making strictly on the evidence and testimony that's presented at the particular hearing, and taking into consideration the various criteria that you've been tasked to apply to a situation. And the idea being that your decisions are not arbitrary and capricious, that they are. There is a record that can be looked to make sure that the applicant has satisfied the criteria and that your decision is based on what took place at the hearing and not something that was brought in, what they call ex parte or outside of the hearing. So with that kind of understanding of the two different types of decisions and the importance that the court will put upon the discretion or lack of discretion that you have in each of those cases, we'll talk a little bit more specifically about quasi-judicial proceedings. And the real key of anything judicial is to make sure that all the parties that are involved in the decision, those that are seeking something and those that are opposing something, are given the opportunity for due process. And in its simplest terms, due process for hearing is that all parties who may be affected by the decision have been provided notice of the hearing and ultimately been given an opportunity to be heard. But it's a little bit more complicated than that. And as I said, as the slide indicates, that there are a number of different things that, that you may be faced with that is a quasi-judicial proceeding. The city council is faced with more opportunities for making quasi-judicial decisions. But essentially what we're talking about in this case is the canal construction special permits. And so when you've got somebody that's applying for a canal special permit, in order to ensure that there is due process on behalf of the applicant, in addition to providing the proper notice, we have to respect that the applicant has the opportunity to make their case by presentation of evidence to you at that hearing, and that you will be relying upon the information and testimony and evidence at that hearing to make your decision. Now, years ago, it used to be that the decision makers were not allowed to make their own site visits of the subject matter of the hearing, or talk to anybody that was had an interest in the hearing, either for or opposed to the particular project. And the legislature determined that, especially at the local government level, that was kind of difficult, not, I guess, to enforce, but also there had been a long tradition of elected officials giving access to their constituents to tell them how they feel about a particular issue. And so ultimately, the legislature determined that, okay, look, since we know it's going to go on, and these conversations are what, as I said, called ex parte, they're outside of the hearing. Since we know it's going to go on, we're not going to let the court determine that the decision will be invalid because of the occurrence of an ex parte communication, but we will require any member of a board or body that is going to be making a quasi-judicial determination, who has conducted their own on-site inspection or has spoken to somebody on either side of the issue, as long as during the course of the hearing, and it's generally done towards the end before the decision is made, there is a statement in the record by the person, board member, that they have had an ex parte communication, or I've spoken with the applicant, or I've spoken with the contractor on behalf of the applicant, or I've spoken with a neighbor who may be opposed, or I've looked at the property. As long as that's in the record, then that does away with the defect with respect to the due process nature of the proceeding. So again, something I'm just going to remind you of. You should try to keep those to a minimum, because I think it kind of detracts from the appearance of impartiality of you as a decision maker. And again, because you're going to be a judge, in the proceeding, you should basically hold yourself to the same sort of standard that a judge in court would be held, and that is, not only are they required to be impartial, but most importantly, they're required to give the appearance of impartiality. So even though I know that you all can, do your job diligently and be impartial, to the extent that we can avoid the appearance of impropriety, impartiality maintains the sanctity of your services. And so if you do have a conversation with somebody that is involved in a matter coming before you, please make sure that you disclose sometime before the decision is made that you have had that conversation. And so again, the next part of the due process requirements are that the applicant has the opportunity to present evidence. Now, when we talk about evidence in court, there's all kinds of rules as to what kind of evidence is admissible in court. We've all seen Perry Mason and other trial TV shows where there's objections to hearsay, for example. And that's the primary objective with respect to the evidence that may come before you. There's a lot of latitude allowed before administrative bodies regarding hearsay. And so rarely are we going to see a decision that's going to be overturned because the decision was based on hearsay. But the idea is that the evidence that's presented to you needs to be presented, number one, under oath, and it needs to be presented by someone who has competency with respect to the opinion or the testimony that they're going to be presenting. If the question is with respect to, for example, impact to navigability as a result of a proposed structure, we should all know that in the absence of someone being qualified to give an opinion regarding navigability, either through Coast Guard training or some other type of experience, or through any other kinds of means of learning about navigation, simply somebody coming in and saying that it's their opinion that this is going to adversely affect navigability, while it's admissible, it probably shouldn't be the basis of your decision in the absence of some other testimony presented in the hearing by somebody else who is competent to testify with respect to navigational impacts. And so if I was challenging a dock, it would be incumbent upon me as an opposing party to bring in somebody, either a Coast Guard captain or someone else who does have the training to be able to make decisions and make opinions regarding navigability, to present the evidence. Simply somebody stating, I think it's going to adversely impact navigation, would not arise to that level in the absence of some particular explanation as to how they came to that opinion. Also, as a quasi-judicial proceeding, just like in the courts, all of the witnesses are subject to cross-examination by primarily the applicant, but also by any party who has established that they have a special interest in the matter, to be able to cross-examine that witness, to make sure that the evidence that's presented before you that you're going to be basing a decision on is what they call competent and substantial evidence. Those are the legal words that a judge would ultimately determine the appropriateness of the quasi-judicial decision that you ultimately made if it was challenged. The judge is going to make a determination as to whether or not there was sufficient competent and substantial evidence in the record to sustain that determination. And I'll talk a little more about that in just a moment. I already talked about impartial voting. It's okay if you know the applicant, It's okay if you know the person who may be challenging the permit, but it's important that those that are watching the proceeding, either personally or through through any other type of media, comes away with the determination that, okay, they may know the person, or you may know the person, but you gave them a fair shake based on the evidence and testimony that was presented at the hearing. And finally, another requirement of due process, another requirement of quasi-judicial proceedings, is that there be a complete record of the matter as it's presented. So, and that includes not just a verbal or video recording of the presentation, but also that if there's any documentation that's been provided as part of a presentation, that it is included in the record that moves forward with the case. So we talked about the importance of competent substantial evidence. Again, it's a legal term. Competent evidence is evidence that, as I said, has some sort of basis. It's something that somebody would believe is fact-based. It's not imaginary. It would be sufficient to convince you in a lay capacity that that's something I can rely upon. It's competent. And then substantial evidence is evidence that, you know, in the criminal context, the standard is that you prove somebody's guilt beyond reasonable doubt. Well, in the administrative context, the burden is not that great, but it means it needs to be at least enough evidence to tip the scale in favor of the decision. And if it's not enough evidence to tip the scale in favor of the decision, then it's not substantial evidence. So the evidence could be competent, but there may not be enough evidence to convince you that the person is entitled to the permit, or that the person is not entitled to the permit. So there's in the presentation of the case, ultimately the applicant bears the burden of demonstrating the entitlement to the special permit based on the competent substantial evidence that's presented at the hearing. But staff will introduce the case for the applicant. The staff will present their findings of fact and their conclusions and a recommendation based on the information that the applicant presents to the staff as part of the application. So the staff's presentation is not really the end-all of what happens before you. It is simply to set the stage for you as to how staff has reviewed the information and how they have applied the facts to the particular criteria. But the staff's presentation is not to be considered to be a satisfaction of the applicant's burden. The applicant still must come forward and present the case, because it's the applicant and the applicant's consultants that the applicant brings in to present the testimony, the competent and substantial testimony that you're to base your decision on. So, for example, if the applicant doesn't even show up for the hearing and all you've got is the staff's presentation, you cannot make any type of finding on behalf of the applicant, because the applicant hasn't presented its burden. Similarly, if the applicant comes in and doesn't bring in anybody who can present competent substantial evidence on the issues that are before you, again, let's use navigational impacts as an example. And the only evidence that's in the record is the applicant's own opinion that the request won't adversely impact navigation. There's not competent substantial evidence that's presented to you to enable you to make your decision. Now, I'm not familiar with what you have done or in the past in terms of decision making and how much evidence or lack of evidence has been in the record to support your positions. But I'm suggesting to you that this is an important part of the process of holding the applicant to the burden of demonstrating entitlement to their request based on competent and substantial evidence. Now, yes, go ahead.
Just at this point, a common occurrence is the particularly...
Fred, can you go up to the
Oh,
microphone?
I can,
I'm
yes, I can.
recording.
Do I need to record my name and say I've been
Yeah,
sworn
it
or
is
something?
being recorded.
No, you don't need to be sworn,
Okay.
No.
not yet.
It's Fred Court, Punta Gorda Isles Canal Advisory Committee. A common occurrence, given snowbirds and all of that, is that the applicant is not here. And typically, it would be one of the contractors who comes representing the applicant. Now, they also have another interest in this, obviously, and that sounds to me like that's a no-no, given what you've just said.
Okay, so often in the application is probably going to have a provision in there where the owner has authorized a contractor to serve as their agent in the proceeding. So when I talk about the applicant, I'm talking about the applicant or the applicant's agent. And so it's not necessary for the owner of the property to be here and present to testify. Although, you know, you may determine that there might be information, evidence that's necessary for the applicant to demonstrate its entitlement to the permit that the agent has been unable to supply. And when we go through the criteria, which is towards the end of the slide, I might be able to give you a couple of examples of that. But as long as there is an agent appearing on behalf of the applicant, and it's an authorized agent, then the fact that the owner themselves didn't appear, doesn't necessarily mean that they haven't met the burden of demonstrating entitlement. Now, also involved in this process is someone who is going to be opposed, possibly, to the permit, or someone who wants to help support the permit, because maybe in the future they may want to come in and ask for the same thing. And so there's an opportunity for someone to get to party status. Now, party is also part of this quasi-judicial proceeding. Parties generally are the applicant and anybody who is officially opposing the application, and they would get party status by seeking to be an intervener in the process. A general member of the public isn't a party. A member is not a party to the proceeding. Theoretically, the only evidence and only witnesses that would be presented to you would be witnesses that are appearing on behalf of a party, meaning the applicant, or witnesses that are appearing on behalf of an intervener. The general public really does not have a role in a quasi-judicial proceeding. I think that there is some discretion that you can have if there is somebody who feels that they have evidence to submit, to allow them to present, after the parties present their case, to present some testimony or evidence. But again, it needs to be sworn, and it needs to be competent and substantial. And ultimately, it's your job to determine whether or not the evidence that may be presented by a non-party arises to the level of being competent and substantial. But again, the applicant and the intervener, generally speaking, the opponent, are the ones that have the party status. And they are required to submit testimony, live testimony, that can be subject to cross-examination, and supporting materials, basically, you know, their plans, aerial photographs, or whatever else that they would want to submit on behalf of their particular case. letters of no objection or letters of support for a particular application are not competent and substantial evidence because, A, they're not sworn, and even if they were sworn, the person who is making the statements in those letters are not available for cross-examination. And so in order to avoid the potential situation of somebody having a very compelling letter that could persuade you to vote one way or the other based on that information, should not be brought or allowed into evidence because it would taint the ultimate decision that you make if the argument could be made that your decision was based to a large extent on this evidence that was not subject to cross-examination and may not have been sworn to, and therefore it is not competent and substantial. So rather than let it in, the better procedure is to exclude it so that there is no question as to how much you may have been persuaded by this ex parte communication that is not competent and substantial. And then finally, as we said, that your decision should be based upon the evidence and testimony that takes place in the chambers that are before you, plus any of the recognized ex parte communications that you present on the record as being part of your decision-making process.
Dave?
Yes.
Jake Dye, I'm on the PGI, and also I'm a marine contractor, so I frequently act as an agent. The letters we shouldn't allow the letters in. What about if a neighbor wants to appear, support personally, and testify? Is that acceptable?
And yes. So if I was the applicant, it would be my job really to kind of round up neighbors that might come in and testify. But bear in mind, the testimony that they give is more than just we support the application. Right. And I'll kind of get to that again. But unlike a legislative determination, where ultimately the legislative body, whether it's you guys when you're considering an ordinance relating to the canals or when the city council does it, they're allowed to gauge the public support for or against a particular provision and base their decision to whatever extent they want to on what they perceive to be the public support. In the context of the quasi-judicial proceedings that you conduct, it makes no difference that there are all kinds of neighbors that are brought in because they like the applicant and say we have no objection. If they don't have any particular testimony to present, competent, substantial testimony, like, you know, a Coast Guard captain comes in and says, you know, I'm familiar with what my neighbor wants to do. I'm familiar with these boating circumstances there, and based on my experience, and this is what my experience is, I see that this would not pose any adverse impact in navigation. But just somebody saying that they're good people, they take good care of their boat and their property, we know that they'll do the right thing, we're all support it. You can have a whole room full of people like that, and that would not or should not change an application that doesn't meet the criteria to an approval on your behalf. By the same token, you could have someone that's the biggest jerk in the whole neighborhood that has all kinds of people coming in opposing what this person wants to do, but if through the competent and substantial evidence that's been presented as part of their presentation, you find that they've met all of the criteria, you should not deny the application based on the fact that there's a lot of non-competent and non-substantial testimony coming in from the neighbors. So it's a heavy burden, particularly, because you're members of the community. Your neighbors are coming in and saying that you should do something, and you might say, well, unfortunately, we're bound to follow the criteria, and the criteria entitles the applicant to a permit. We're sorry you don't like it, but that's the way it is. So that's why you guys get the big bucks for what you do. All right. So
David, one quick question on that. Gary Disher, engineering, the cross-examination process, who does the cross-examining? You know, are they there asking for staff to do that, or is it the board members? How does the cross-examination process work?
Okay, only a party has the right of cross-examination, both the applicant and anybody that's given party status as an intervener. And so every witness is subject to cross-examination by the opposing party. Now, there's nothing wrong with you as a board member asking questions for clarification purposes. Even a judge is entitled to do that. But it's neither staff's nor the board member's obligation to cross-examine the witness. Although you might find it helpful if the applicant presents a witness and there's no cross-examination by opposing party, you may question the competency of that evidence. You might want to ask a few questions, to be able to satisfy yourself that this person knows what they're talking about. If they don't do a pretty good job when they're first presenting their testimony of talking about their background and what kind of experience they have with respect to the issue at hand in order to render the opinion that they're rendering, you might take it upon yourselves to ask some questions which technically isn't cross-examination, but serves the same purpose of testing the competency of the evidence that's being presented. So in this process, our ordinance presents certain procedures that ensure the due process and the assurance that your decision will be based on competent substantial evidence. And here's a slide of 10 steps in the conduct of the hearing. All the parties, all the people that are going to be presenting evidence and testimony should be sworn in. I know traditionally, if the applicant comes with an attorney, the attorneys get sworn in, but bear in mind, the attorneys are not offering any evidence. They're not witnesses. All they're doing is arguing, both in the figurative and the literal sense, okay? Their argument isn't considered as evidence, but traditionally they get sworn in anyway. But anyone, even a member of the public that's going to be providing some sort of testimony needs to be sworn in. And when they do come up to the podium and they do present their testimony, they do need to note for the record that they have been sworn. So the staff presentation, we say a maximum of 30 minutes. I think that the chairman has the discretion if it's a particularly complex case and the staff's presentation may take longer to allow for longer than 30 minutes. Same thing with the applicant. The applicant is given a maximum of 30 minutes, but again, we don't want to deny the applicant the opportunity to present their full case. And if you feel it's appropriate, the board can grant, in its discretion, more time. Same with a party intervener. They are given a particular period of time. I think, like I said, it's customary because it is considered to be a public hearing of some sort, even though it is a specific quasi-judicial public hearing, to allow for members of the public who may want to weigh in on the matter to speak, even if they're not a party and they're not a witness called by either side. They may have some pertinent information that wasn't disclosed by the applicant and wasn't disclosed by the intervener that they may be able to present. And ultimately, they're given 3 minutes to do that, and they need to be sworn. And ultimately, they may actually present competent, substantial evidence that may turn your decision. But as I said, it's got to be competent, substantial, and simply there's a statement that they don't like the project and aren't able to articulate a particular reason that's governed by the criteria to oppose the project, you'll consider the weight that you give to that evidence, but as a courtesy, you'll let them have 3 minutes to have their say. As I said, you can, as members, you can ask questions all throughout the presentation. At some point in time, it will appear that the that the evidence and testimony has come to a close, and the members will vote for a motion to close the public hearing. And it's at that point in time when the members will conduct their deliberation in public of the matters that were presented in the record before you. There is an opportunity for the public hearing to be reopened if during the course of the deliberation there was a question that comes up that maybe needs to be answered. You can reopen the public hearing. You can ask the question of the applicant to present some additional evidence. You can ask the question of the intervener, the opposing party, to present additional evidence, and any evidence that's presented during that course, as well as, when I talked about cross-examination, staff isn't necessarily a party to the proceeding, but they are also subject to cross-examination, and their cross-examination by either party. They can be brought up to clarify something, and then, of course, then also be subject to whatever cross-examination somebody may wish. And then ultimately, when you've determined that all of the evidence is in, the public hearing is closed, and it's the opportunity at that point in time for you to weigh the evidence that was presented to you based on the criteria that you have before you. And the interesting thing about these special permits is that it's a little bit different than a regular permit. To get a regular permit, you need to just simply present an application to the staff and make sure that your plans, what you propose to do, meet the regulations that are in the ordinance. It should be, straightforward. If you meet the requirements, you get a permit. If you don't meet the requirements, you don't get a permit. And if you don't get a permit, there's an opportunity to challenge that. But, I said those are pretty straightforward. In the context of the special permit, frankly, it's more in the nature of a variance than it would be for a regular permit. And that's why it's a much heavier burden, quite frankly, upon the applicant to come before you to satisfy you through the presentation of their competent and substantial evidence that each of these criteria that are in the ordinance are satisfied. And if not all of the criteria are satisfied, the ones that are maybe applicable in a case, the applicant is not entitled to the special permit. So there may be one or two of these things based on what they're asking for and the circumstances that may not be applicable. So you can't force them to prove something that's not applicable. But clearly, like item C, would not impede safe navigation. If the applicant has not presented competent and substantial evidence by way of testimony on the stand, or by way of a survey that would be necessary to determine or show that the proposed structure won't impede safe navigation, then they're not entitled to the permit. You have to deny it, even if everybody says all the neighbors say it's okay. So each of these criteria have to be considered by you based on the evidence and testimony that's in the record that comes before you at the time of the hearing, plus to a much smaller extent based on whatever ex parte communication, site visit, or whatever you had. I just think as a general proposition, you should minimize as a judge the value and opportunity for the ex parte communications and base your decisions on the evidence that's presented before the hearing. Because if you deny a permit, a special permit, and that's challenged, and there's nothing in the record that's before the hearing that would satisfy a court that the denial was based on either competent substantial evidence or lack of competent substantial evidence, the presumption is going to be that the decision was not based on material evidence and documents that were presented in the record, but maybe something outside of the record, which smack of some degree of lack of impartiality, for example. So it's a better practice to minimize ex parte communications, and it's a better practice to insist that the parties to the proceeding present the competent and substantial evidence necessary to support their positions. Yes. I think you're, yeah, I'm sorry.
Jake Dye. Not granted for structures which are strictly prohibited. What's the definition of strictly prohibited? For example, the code says that all structure has to be inside the 45, but we approve routinely structures that have like 2 pilings outside the 45. Even though the code says has to be inside the setback limits, we approve structures that are not. And so
Yeah.
what is strictly prohibited?
Gary, you want to give a better example of what is a strictly prohibited structure? I mean, I think the purpose of special permits is to address those things that aren't specifically authorized. And in many cases, things that aren't specifically authorized may be, in other contexts, prohibited. But maybe, Gary, you can give a better example of what
I'll
would be.
give a shot. I would think, we've got our berthing limits, and say a piling that lands outside of a berthing limit, or would allow a vessel to encroach into a navigable channel, outside of the 25 foot off the seawall, things of that nature, I would think that may then be a strictly prohibited item, because then you're blocking navigation, being out in the channel. I know we've always set our bounding limits as the berthing limits within our footprint for these permits, so I'm thinking
Yeah,
that'd be about the best shot.
Mikhail just reminded me of a couple of issues that are better examples of what is strictly prohibited. A boat lift cover in the ordinance is strictly prohibited. Putting a structure within the navigation channel is strictly prohibited. I would suspect the argument could be made that if it doesn't specifically say in the code that it is strictly prohibited, then it may be permissible by means of a special permit if it's not otherwise permissible under the provisions of the code as a regular permit.
So Jake Dye again, the latest change to Chapter 6 gives us some greater meaning to navigation channel, and I'm thinking about BSI specifically, where we define the navigation channel as the center of the canal, and you got something that's pretty narrow. Under the old code, we frequently looked at it and said as long as there was 40 feet there, then we were good to go. Now with the code, that 40 feet has to be measured based on the center of the channel. Does that strictly prohibit if you violate that 40 feet as measured by the center of the channel? Is that a strictly prohibited?
I believe that was the intent of the revision, was to maintain the safe way so that safe navigation would be provided, and to make sure that there was a clear understanding of how that safe way was determined. Okay, so.
Sean Harrigan, I'm on the BSI committee. Procedural question. You talk about reopening the meeting. So we call to close the meeting, and then do we have to reopen the meeting in order to ask for further testimony?
Yes,
And then we have to call 3 times again to close the meeting?
correct.
Thank you.
Yes, go ahead.
This has all manner of things in it, Fred Court. Just an assumption about impeding safe navigation. I don't think we have ever had in PGI in my time, anybody come in and affirmatively provide testimony that it would not impede navigation. There are some obvious cases where there's an issue. Can we assume, or should we assume, that if it's not outside the berthing limit, if it's not doing something that gets that 40 feet that Jake talked about, that it's okay? Or do we need to have some competent testimony on not impeding safe navigation? And I have more questions.
Okay, well, since the city council was the legislative body that adopted the criteria, and since the city council is presumed to mean what they say, then there needs to be affirmative evidence for each of the applicable criteria, including someone to testify that it would not impede safe navigation. Now, it could be the contractor. And the suggestion has been made that, well, the contractor has a vested interest, in testifying so that they do the work. And that's fine, as long as there's nobody that cross-examines the contractor or is able to present contrary evidence that the contractor's opinion that it would not impede safe navigation is not competent or substantial evidence. But there needs to be testimony, and we need to make sure that the regulated community understands that they need to do their job in making sure that there is evidence presented in the record that supports each of the criteria. And the fact that we may not have been holding them to the fire in the past, I think is a bad precedent to maintain what was done in the past, given the fact that our communities are getting to be more built out. There's more people that are wanting to have the permits that maybe not had the permits in the past, that there's plenty of attorneys out there that are willing to take business. We need to make sure that we're making sure that everyone is held to the standards of the ordinance.
And in the application itself, the applicant is asked to identify whether it would impede navigation.
Sure.
Or that whole list of things.
Yeah.
And so there is evidence presented by somebody, and what you've said, I think, is as long as nobody objects to it, then we're on at least semi-firm ground.
No, the application is simply the vehicle that gets the matter before you. There needs to be still independent, there still needs to be evidence and testimony presented, subject to cross-examination. It's probably gonna make more work for contractors or consultants, but that's what's required. Otherwise, it would be, if I was in private practice, contesting this, it would be very easy for me to say, okay, give me a copy of the record, and the city's obligated to give, as a public record, the record of the proceedings. And if there's no evidence in the record presented before you at the hearing regarding whether or not the proposal would impede safe navigation, it would be very easy for me to be able to overturn that decision because there is no evidence in the record to support that particular finding. And that's why when you make your decision, if you make a determination that you're denying the application, go on up, I'll call you in just, please. You're denying the application, you have to state the reason why you're denying the application. You don't have to state that every one of these criteria has or has not been met. You can simply state that there was no evidence presented in the record that the proposed project would not impede safe navigation, and that would be sufficient to uphold the decision to deny the permit. On the other hand, if you were going to make a motion to approve the permit, you would have to make a motion and say, I have found that, or I make a motion that there's competent substantial evidence that the proposed project, and then go A through F, where applicable. So that on the record, there's a finding of the facts, finding of your conclusions of law, which basically your determination as it relates to the criteria is what's considered to be a conclusion of law. You're applying the facts to the particular criteria that activity is making a conclusion of law, which then would be part of the record to support it or to support a denial or support the granting of a permit. Sir.
Mark Kuharski, PGI. I have one comment, actually, and one question. The comment is, but it appears to me that we may be denying a lot more applications than we have in the past. So my suggestion is that you do this same thing for all the contractors, because otherwise what's gonna happen is we're gonna be denying stuff and people are gonna go, what? You've approved this before and now we're not gonna be approving, and then it's gonna be on us and we're gonna be the bad guys. So I think if you're gonna do this for us and tighten it up, I would suggest you do it for them. And then that's kind of my other question is, what you hear a lot is, you know, you set a precedent, so we've done this before, and how can you not do it for me? So how does that play into all this? I mean, if there is a precedent, I mean, is that meaningful or not?
Well, and I appreciate the comment. In fact, I believe one of the reasons why this presentation is being recorded is that we do have the capability and probably should, as you suggest, make sure that the contractors are aware of it. And even if there's a new contractor that comes in or a new applicant comes in, it would behoove them to listen to or view this presentation so they understand what the ground rules are going to be. Now, the law is the law. And I'm going to simplify this argument because there clearly are arguments that I can make or others could make that would be contrary to the statement. Every case is determined on the facts and circumstances of that particular case. So the granting of a permit for one situation should not serve as precedent for the granting of a permit in another and vice versa. They each stand on their own. And the requirement is that every request for a special permit must meet the criteria that's set forth by the city council. Anything that's been approved in the past, while it's legitimate because it was approved and it wasn't timely appealed, so it's final, does not necessarily mean that it was correct at the time that it was adopted. So moving forward, hopefully the applicants would be held to the correct standard for issuance of a special permit. And the type of evidence that's necessary to support that will be considered by you. And the public will understand that just simply coming and opposing a application is not sufficient if they don't seek intervener status and then bring in evidence and testimony to challenge. Because if they don't seek intervener status, they're not a party, and therefore they don't have an legal ability to challenge the issuance of the permit. And so if I'm a neighbor and I want to be having a legal standing in the proceeding, then we do have a means to do that, but they have to follow that means in order to come into the proceeding as a party. And then after you've made your decision,
Can
yeah,
we just,
go
I'm
ahead.
sorry. D and E, it's again Fred Court. One of the most frequent things that happens in our proceedings is that the neighbor comes in and says, they knew what they were getting into, and this is going to block my view, or something like that. And nobody's coming in citing the aesthetically or, peaceful and quiet enjoyment. But if they did, this is what they would tend to rely on, and which would put us on the spot to know whether that is a reasonable objection and whether they're competent, as you've said, to make that case. In some cases, in fact, in most cases, they're saying, because of what my neighbor is going to do is going to diminish my future sale value of the house. And we hear that probably every time we're talking to an applicant. What do we do? How do you handle that?
Well, that's why you're the judge and I'm just the lawyer.
Thanks a lot. That's where you get the big bucks.
All right, so one thing about view and a misconception is that if I own property that abuts water, then I have riparian rights. And traditional riparian rights include the riparian rights of view. Well, first of all, that only applies to natural navigable waters. Riparian rights do not apply within artificially created water bodies, which most of our canals are. I also have had to counsel in my private practice. And, I don't know if you know it or not, but, I'm a city attorney, but I have a fairly substantial private practice in waterfront property law. And although I can't practice before the city and before you guys, I do so in jurisdictions all around the state. And I'm often asked by a neighbor who is complaining about a structure that's going on his neighbor's property, that it's going to affect my view, and they're upset about it, they want to challenge the permit. And one of the things, I look at is, first of all, is the water that they're on artificial or is it natural? If it's natural, there are riparian rights, but even still, there's on a natural water body, and the allocation of riparian rights between neighbors isn't whatever the person thinks that they want to be able to see without having an obstruction. And so there's a lot of law that describes, how you determine, for example, with respect to view, how much view is a riparian owner entitled to. Fortunately, for the most part, we don't have to get into that here because, as I said, it doesn't apply. But I've even had clients that objected to a neighbor putting up a fence along the property line because it was going to adversely affect their view across the neighbor's property into the main body of water. Well, riparian rights, in no case, goes over land. So, yeah, there's going to be any number of reasons why a neighbor is going to be opposing a dock or a lift, particularly if they're used to not having anything there, and now all of a sudden there's a standard lift with a boat that's going to be raised up, that's going to affect the opportunity to look out across the water beyond what even would have been their traditional riparian view line if it was riparian rights view applicable. So the only thing I can tell you is that your job is to follow the law and explain to the person who is objecting that our law is not designed to make sure that you have an unlimited view of the canal. And that's where stuff like D, E, and F are extremely difficult in any context to administer because it's so subjective. But there may be an instance that would clearly fit within that category that could be supplied by competent and substantial evidence. You don't need to have an expert come in and say that that the structure would be aesthetically compatible necessarily. That's something that experts don't need to be testifying to. But you can make a determination based on what is being proposed, although I can't conceive of one, that you would ultimately make a determination that whatever is being proposed is not aesthetically compatible with the existing structures. So that's why things like D, E, and F probably shouldn't be the only basis for your denial of a permit. I would probably stick with A, B, or C if you were going to go into a denial route. And then I believe I'm about to get the hook. Is that why you're?
No, I just had to expound on his question.
Okay, thank
We've
you.
had, for example, a couple people, neighbors that present evidence that a different lift that is within the criteria would be better. So is there a good response to that? We've had quite a few of those where instead of, going outside of this, here's a lift that would work. So is that substantial evidence, and, how do you handle that?
And that's a great question, because it does give me an opportunity to talk about really ultimately what the courts are going to look at. in terms of upholding or deny or overturning a decision. So if I'm an applicant and I submit sufficient competent substantial evidence to show entitlement to a permit, even though the objecting party may also present competent and substantial evidence that would say, no, you shouldn't get a permit, you're entitled to decide based on your expertise, based on your understanding of the code and all that, as to which competent and substantial evidence should carry the day. And as long as there is competent, substantial evidence to support your position, it doesn't matter that there is competent and substantial evidence that might be opposed to your position. The courts are not going to reweigh your determination with respect to ultimate findings. Now, I know that, and one of the things that I was asked to comment upon is your ultimate role as the decision maker, and maybe I can go and describe that with this slide. When you make a determination to grant a permit, you also have the ability under our code to prescribe certain conditions that might minimize some of the adverse nature of the proposed project as you perceive it. In other words, you have determined that there's competent substantial evidence in the record to support the approval, but that if there were certain ways to make the permit somewhat more compatible, let's say, with the neighborhood, there are certain conditions that you can impose. But this is also a very tough provision. If the applicant has demonstrated that they are entitled to the permit, even though you think that there might be some ways that they could modify the permit to make it a little bit better, you cannot impose that as a condition. You can ask the applicant if they were willing to consider that. And if they were willing to consider that modification, you can grant the permit with that modification as a condition. But if they decided that, no, we would prefer to have it the way we want to have it, and they have provided substantial competent substantial evidence to justify the application, you can't deny them because they have rejected your proposal to make some sort of modification. Nor can you ask them to go back and reconsider or work with your contractor to come up with a better plan, or meet with the neighbors to try to figure out a way that the neighbors might be more amenable to it. You have to make your decision right then and there at the hearing, and you need to make a decision based on the evidence and testimony presented and the criteria that's been provided, even though you think there might be a better way to do it. Then there's, as I said, this is more of a repeat of what I've already talked about concerning the record and the basis of the decision. And Gary, you have something to ask.
Gary Bishop for the record. Another thing that comes up a lot is how big of a boat, what kind of a boat are you putting on this lift? And I know that's not something that these guys regulate as boats, but that gets brought up more times than not on what are you putting on it? How big is it? So could you address that? I mean, we can't make a condition of you can only put a 22-foot boat on there. If he wants a 28-foot.
Right. If there are some, I'm going to give you a hypothetical, but there are some jurisdictions that not only require the structure to be within their particular setbacks, but also say that the structure and boat has to meet those setbacks. I was asked to take a look at a situation where we had a property owner who was putting in a boat that extended beyond their property lines, that the boat itself was, encroaching upon their neighbor's property. And this was not one where riparian rights was at issue because there weren't any, it was again, a man-made water body. And that particular jurisdiction did not have any restrictions on boat sizes or limitation to extend beyond the property line. So we don't have anything in our code either that limits the size of the boat. As long as the structure is within the parameters that our ordinance provides for, then it makes no difference as to what type of boat they want to put in there. And so that would not be a competent and/or substantial evidence to base a denial of a special permit. And so it's really not even pertinent to ask that question as to what size boat do you want to put in there? Because as long as they're able to meet the structural requirements, it just doesn't matter. Now, one of the functions of this board is to make recommendations to the city council as to how the ordinance can be improved. So if there was a majority of you that felt like that, well, our ordinance needs to provide limitations as to how big a boat can be so that it is reasonable based on what you think a reasonable use of our canals would be, then that's a recommendation you can make to the city council and let the city council decide whether they want to amend their ordinance accordingly. Sir.
Rick Doherty, BSI. I hear what you're saying, but my understanding is since 2001, at least in BSI, all boats have to be on a lift.
Yes.
And if that's the case, then if that boat has to be on a lift and we have criteria on the size of the lift, then that pretty much sets a standard for the boat being within the limits that's set. Because the boat has to be on a lift.
That's a unique circumstance because when the city got the permit to remove the lock, the state felt like that the lock itself provided a water quality function to protect the waters of the heart of the bay. And so as a trade-off, whether rightfully or wrongfully, whether there was any scientific basis for it or not, they required the city to require all of the docks, the new docks after that date in BSI to be equipped with lifts and that the boats be put on the lifts. The idea being that the stuff that the state was concerned about, the toxins from the bottom paints and all that would be kept out of the water. So, I mean, there is a limitation as to how big of a lift you can put based on your criteria.
That's correct.
And that will provide some sort of limitation as the size of a boat. But that's something that we have little control over.
Now, the exception is that you can have a bigger boat for a maximum of 30 days in the water over a 12-month period. So if somebody wanted to bring in a bigger boat, they could only keep it in the water outside of the lift for a maximum of 30 days.
Yeah, but that doesn't come before you, does it? I don't think so.
No, I mean, but people have asked me a number of times, I got this big boat, and what about giving us an exception? I'm saying the rule is, it's gotta be on a lift.
Yeah, well,
Yeah,
and that's because the city is subject to a state permit that is enforceable by the state. And so the city doesn't really have the discretion to allow boaters to bypass the requirement that the boat be on a lift. And clearly, you would not have the jurisdiction to even consider that. I would consider that to be another one of those things that would be strictly prohibited by the code or other circumstances that would preclude you from issuing a special permit.
I agree. I mean, I don't have any problem with that, but I'm just saying that based upon the need for a lift, at least in BSI, you can't have a boat that's bigger than the lift.
Right.
And the lift has to be within the structure, within the code itself, basically.
Yes, correct.
Okay, thank you.
Mark Kuharski again. So, question on the size of the boat then. There's a particular situation where we encountered a while ago where the boat that the individual was showing and the way he was showing it that he was gonna moor that boat on his dock, not on a lift, but on a dock. It was clear, as being boaters with experience, that that was not really what he was gonna do. And if he did it the way anybody else would do it, his boat was gonna encroach over the property line of his neighbor. So, I mean, is there some kind of reasonableness that we're allowed to consider when we know that what he's showing is showing it as a certain way to get the permit so it looks okay, but the reality is that's not gonna be what happens. So do we have that kind of latitude, or is it just we can't consider the size of the boat at all?
So let me try to, I will try to give an analogy from my experience, in other jurisdictions on behalf of applicants. So for example, in Sarasota County's ordinance has a requirement in order to protect seagrass, that that there must be a foot of clearance between the top of the seagrass and the lowest part of the vessel. So you consider, you assume that if there is seagrass there, the seagrass extends a foot above the water, then there's this other foot, like no man's land, and then you have the vessel sitting on top of that. And so the trick is, well, not the trick, but the requirement is to show in your application that you are proposing a vessel of shallow enough draft that when that vessel is moored at that dock, that you'll be able to maintain basically the required 2 feet. Now, when that restriction first went into being, there were a lot of people that were showing in their plans that boats with like 9-inch drafts, which they're out there, they're flats boats. And they would show that that's what they were proposing, and so there would be a measurement, okay, I see 9-inch draft, and we got your bathymetric survey shows you got 2 feet to work with at mean low, and they would grant the permit. Well, what was happening is that 9-inch draft boat never was purchased, and it would be a boat with a deeper draft that was being put at that dock. So when Sarasota County realized that that was happening, they would then make the permit conditioned upon that the maximum draft of any vessel being there would be 9 inches, so that there'd be something that could go out in the future if they needed to prove that there was a violation, in violation of the permit. So if you have an application that on the face of it looks like it's meeting the criteria, but you, based on your experience, and that's why you're members of this board, I mean, you're here because you've got certain criteria you can bring to the table, that you believe there's no way that person could ever actually dock the boat the way that they're showing it, that particular boat or whatever, then yeah, you can put as a condition to the permit that the boat may only be moored as shown on the approved plans, or whatever it is that you need to do in order to make sure that there is something that's enforceable with respect to what they're presenting to you. Because, as I said, they're presenting to you something to try to get you to approve the permit. But you have to make sure that once the permit is approved, there is still something that can be enforced. And that's why these conditions, and that's a very good example of a condition that could be made part of the application itself.
Bob Nicola from engineering. In the particular case that Mark described, in BSI at the end of the canal, you're allowed to moor a boat or have a boat up to 35 feet waterward. The applicant didn't show up at that hearing. The contractor claimed to not know what size boat he was building this lift for. But the next door neighbor who presented testimony said he is trying to fit a 39-foot boat on a lift and only extend out 35 feet on a lot that had 45 feet of seawall. So I think it put the board in a very difficult position to not be able to you know, on the paper, it showed where the lift would go and everything looked good on paper, but from a practical standpoint, I don't think it could be expected to stay only 35 feet waterward. So would the board be able to say, you know, it's understood that you can't extend past the boat limitation line or the outermost limitation, 30 or 35 feet, whatever the case may be at the end of canal. But I think that's why the question comes up, what size boat? Because however the lift is angled or positioned, the big question is how much boat is going to hang on the back side of that, or the most waterworks side of that lift, and will it extend past the boat limitation line?
Okay, so if we have a concern that a limit in our code may be exceeded by the application, if the applicant hasn't, through himself or his agent, presented competent and substantial evidence to demonstrate that the criteria won't be violated, if in fact there is reason to believe that that's an issue. Reason to believe by the neighbor testifying with respect to what he understands the intentions are, you as staff looking at what the design is and how any reasonable person would believe that you can't put anything but a much smaller boat in that situation. You know, the board can make a determination that that the applicant has failed to meet its burden of demonstrating full compliance with the standards. So, yeah, I mean, if the issue is raised and the issue is a valid concern, and if the applicant is unable to present the competent substantial evidence that's necessary to rebut that presumption, you would be within your full rights to deny the permit. And that's where staff actually comes in the process, because staff may have some inside information or some better understanding of what could be the intention of the applicant. And then under those circumstances, if you were to grant the permit, which probably if there was no, you know, it's easier to, or better legally to grant a permit with a condition than to deny a permit where you feel like sufficient information hasn't been provided, because there may be an argument or a dispute as to whether or not sufficient information was, and a judge might determine otherwise. So in a situation where you think that the size of the boat is important to ensure compliance with a particular requirement, then, you know, staff bringing it to your attention, the applicant not being able to refute that concern, you can make a limitation in order to comply with the requirement, part of the issuance of a condition of the permit itself.
Okay. And then just, two other questions. For the person to be considered a parte intervener, it says that they have to submit the request 7 days in advance. And who do they submit that to? Because I'm just thinking timeline-wise, when it goes in the paper, and, you know, I put the sign out in the front yard, my name's on that, and typically people who are opposed, you know, contact me. And should I be asking them, hey, do you want to serve in this role? And if you do, how do you do that?
Well, Mikhail, you want to try to explain the procedure?
Yeah, typically, that happens, when it happens for other things, like variances, special exceptions, they do contact the staff member. And then we work, you know, tell them, we give them a copy of the procedure, this is what you have to have for intervener status. A lot of times when it's an intervener, there'll be an attorney involved. They've already had someone, because again, their interest has to be something other than just the general public. So, yeah, I would say that they would contact staff first, and then you would work with the legal department to.
Okay.
And then let me follow up on that. I mean, in my private practice, I'm sure this is customary, other attorneys find the same thing. A neighbor will be thinking about, objecting to a neighbor's dock and be aware of the hearing, or maybe they just become aware of the hearing shorter than the time frame for filing the intervention status. If they contact an attorney and the attorney wants to be present, typically what we'll do is we will recommend or simply put the permit onto the next hearing to allow the objecting party to have appropriate legal representation to serve as a party. Otherwise, they're coming forward and they don't have party status, which in some respects is a denial of their due process. I mean, there's no due process right to have an attorney present for an administrative proceeding, but decisions that you make could adversely affect their legitimate property rights. And so in an abundance of caution, we try to recognize that this is a relatively informal procedure. Most people aren't necessarily familiar with the rules of procedure, and to make sure that everybody gets their opportunity to be heard, which again is a requirement of due process, to be heard and be heard with adequate preparation is also consideration for due process. We'll make an accommodation like that. But ultimately, if somebody comes up at the day of the hearing and they have an attorney present, or say we want to have an attorney, you have the discretion, and they want a continuance of the hearing, you have the discretion to deny it, because again, to some extent, it's unfair to the applicant who's paid for a consultant to be present, may have come in from out of town, or what have you. So the decision to grant or deny a continuance of the hearing is also within your sound discretion.
Okay, and then the last question, or just under the criteria, under D, we're not allowing a structure or use aesthetically, I think is one issue, but functionally, we've, in the last 5 years that I've been here, we've probably processed very close to 100 special permits. Not all of them are at end of canals, some are for a second boat lift, other things, but typically, the objection at the end of the canals is the corner lots that don't have much frontage, and the neighbor who may have built a permit or built a structure with a permit that was somewhat short-sighted, that in order for them to use their lift, they have to cross the boat limitation line on a neighboring property, and they've done it for years, and all of a sudden that's going to change. And they will argue, that's not functionally compatible with what I have, but I think the owner who's trying to present their special permit application says, they really don't have any right to use that water. That's, if I could legally put a boat there in the water within my boat limitation lines, which would effectively shut off your ability to use that water to get on and off your lift, or even to moor your boat next to your dock. But I think that when they present that argument, is the board within their rights to say, well, your plan was somewhat short-sighted and that neighboring owner has the right to use that water behind their house. You don't have that right to, or can they just say that's not functionally compatible with what I have? I don't care whose water I have to cross to get on and off my lift.
Yeah, and I'm sure that there are a number of circumstances, given the kind of the age of the city, the development history of the city, that docks have been, and given that the fact that the ordinance itself has changed over time, that there may be structures that were legally permitted that at the time, it was a sparsely developed canal. There wasn't any, the properties on either side were vacant. There wasn't anybody to come before the city to object to the issuance of the permit. And the permit was granted, that today may or may not have been granted. There is a vested right to maintain that that dock or facility that received the permission from the city. That may now frustrate the new neighbor, the new owner next door from doing what they would like to do. And that's where, you have to determine in that circumstance whether or not, even though the problem was caused by what the city council may have approved back in the day, still is affecting the newcomer's rights. You have to maintain at least the fact, or recognize the fact that that structure is legal. And if it is, it may, from our perspective, prevent us from granting a permit to the newcomer. And you would have the right, based on paragraph D, to make that denial. And it would be up to the newcomer to seek whatever recourse that they may have, not against the city, but maybe against the neighbor for somehow infringing upon their rights, if they have any cause of action at all. I mean, as I said, there's, especially at the ends of canals, there's all kinds of fact patterns that complicate the situation immensely. And all you can do is exercise your jurisdiction under the criteria that's been granted. You can't right all wrongs. And if the end result is that the last person to come to the canal is otherwise somehow precluded from having a dock, but that's what the criteria, that's what, the facts present, you've got to deny it, even though, the reason why they bought the property was because they wanted to have a dock at their property. I don't envy you in having to make a decision under those circumstances, but bear in mind, buyers of property, particularly if, this is a newcomer, have an obligation to do due diligence before they purchase that property. And they need to determine whether or not the property is going to be reasonable, allow for their reasonable expectations of the use of the property, and should make that determination before they close on the property, if they can, and not close on it if it turns out, based on doing the due diligence, that they're not going to be able to have a dock. I mean, I know staff is more than willing to talk to a prospective buyer of property as to what the limitations might be with respect to that property based on the existing structures. And hopefully people take the opportunity to do their due diligence. I mean, that's what I do in my private practice, is I advise buyers of property as to whether or not they can put a dock in. It could be that the water's too shallow and they're not gonna be able to meet, like, for example, that 2-foot separation. And fortunately, they come to me and they get that information before they close, and then they look for a different property. Unfortunately, too many properties are bought without doing the due diligence, or relying upon misinformation from whoever it is that they're relying upon. But that's not your job to fix that problem. Your job is to apply the ordinance under the facts that present themselves. And then, I guess finally, I've been talking a lot about the appeals, and I've talked about overturning your decision. Frankly, it's the city council that would be hearing any appeal of a denial or of an issuance of a permit that comes before you. But when the city council does consider an appeal, it's not like they determine whether or not what you did was right or wrong. They are hearing it as if they're hearing it for the first time. It's called de novo review. So they have to hear and conduct a hearing that's very similar to the same hearing that you conducted. And ultimately, again, it becomes the applicant's responsibility for demonstrating the entitlement to the permit. And if the applicant, gets a favorable decision from you, And then the neighbor, who was an intervener in the case, before you, it takes an appeal of that to the city council, the applicant that just sits home and relies upon the action that you took may find themselves losing that case, because at that position, at that point, I will be advising, the city council as to what they need to do and what evidence that they need to be considering and what their role is, and that they can't simply rubber stamp your determination. That's good or bad, but that's their role in this whole process. And it's only the denial of a special permit or the granting of a special permit without competent substantial evidence that can be appealed to the circuit court. Any other questions? Because I've come to the end of the presentation.
Just back to the Fred Court again. One of the most frequent requests for special permits that we get are in those end of canal, keystone kind of lots where they've got 35 or 40 feet or even less, I guess, in some cases. And a philosophic sort of question has sort of pervaded our deliberation, that this is a waterfront community, this is a harborside hometown. Anybody who comes here should, in essence, have a right to have a boat in their backyard. That's not what we say, but that's sort of the mental process. So when a permit comes, it's frequently, two posts outside the 45 or something like that. And we've been periodically accused of never seeing a variance that we didn't like. And so we grant those things on the basis of that harborside hometown. We hope that you have it. Sometimes there's no objection, but in some cases the neighbor says, you got an ordinance that says you can't do things out that. Why are you granting that special permit? They don't necessarily have an objection other than you're granting a permit against the existing ordinance. Are we on shaky ground? Is that, because we can't use precedent, and we have a lot of those precedents. So this is individual case, and now we have to say, oh, sorry, this is what we have to do here. Are we now, I'm looking at our guys, going to have to take a step back from that and say, unless you have a compelling reason, no. Anyway.
So, and the solution to that situation is not and should not be placed on your shoulders to do what is fair. If the city council has adopted regulations that are very clear and haven't given you the jurisdiction to deviate from those requirements in order to do what might be perceived to be fair. The solution to the situation, if the city council chose to pursue a solution to that situation, because there's reasons why they may elect not to, and I'll go into those in a second, is to provide a mechanism in the ordinance which would allow for relief from a situation like you described, provided that the adjoining property owners who would be maybe adversely affected by those additional poles gives the applicant an affidavit of no objection based on a particular site plan, indicating that they have no objection to that. And that gets filed with the record, and actually should be filed, the procedure would be to also file it in the circuit court, so that a subsequent purchaser of the property who granted the no objection will be made aware of the fact that they're now buying a property that may have piles that may affect them. That is typically the way the situation is addressed in other jurisdictions where riparian rights is the issue, and somebody needs to put a dock closer to the riparian rights setback line than would otherwise be provided for in their code. The state, for example, requires a 25-foot setback from property lines extended, or riparian rights lines from a joint property line. And it's not uncommon because of the size of a dock or the configuration of the dock on the neighbor on the other side of the property to need to have a dock closer to the riparian rights line than that 25-foot setback. And so you can get a permit from the state, provided you get that written affidavit of no objection as recorded and all that. That may be the way to resolve a situation like you've just described, but in the absence of that type of a resolution, you don't have the jurisdiction to be providing for equitable relief. I mean, you don't. And then the other side of that argument is going to be, well, look, especially if it's the last person to come to the party, and they have to accept what's already there in their decision-making as to whether or not to buy the property. They can't buy a property that's not suitable for what they want to do and then force themselves into the property to the expense of those that have legitimately done what they were allowed to do, whether today it would be appropriate based on our current code, or as long as it was appropriate back in the day. And even then, if it was built in violation of the code back then, and a sufficient amount of time has elapsed so that there's really not an opportunity legally to do anything about it, everybody's stuck with the situation. I mean, that's just the way it is. Sometimes there isn't a solution that make everybody happy. Sir?
Is the letter, Jake Dye, is the letter or the affidavit of no objection, is that an adequate replacement for the letter from the neighbor saying, hey, I don't care if he puts that lift in?
No. I mean, our code would have to be modified to allow for that as to be justification for deviating from a code provision.
Ron Ludwig, BGI. What is the role of the committee during an appeal? Do we have any role at all, or are we just completely out of it?
You're completely out of it. Now, your determination will be made part of the record that goes to the city council. But the city council, as I said, because it's a de novo proceeding, is really to give no weight to that whatsoever. But it's part of the record so that they, part of the record before them so that they see that they have a basis of jurisdiction. Anything else?
Thank you.
Thank you all very much. I appreciate your attention. Yes.
DEP state says, man-made canal in the way of the dock, got a permit, pull them out.
Yep.
And federal says,
Do that.
National Fisheries, Silver Lane, Charlotte Harbor, you have to get, file an application through the DEP, or Corps of Engineers and National.
Fighting for them, whatever it is.
I don't know, and that's the problem, I've been forced to do that now, but I'm finding there's a company down in Fort Myers that says, no, this is not federal water, this is artificial water. Federal requirements don't have a play in it, and the state rules apply.
Well, there's certain things that the state has delegated by national permits, for example, to the Corps, has delegated the state to national permits. They're not really considered exceptions or exemptions, but have allowed the state to function on their behalf. And I can't put my finger on anything as it relates to mangroves, but
They said that, as far as the application.
Well, the state regulations are pretty clear.
They
I know what you're talking about.
No,
I know
but
exactly
they
what
can
you're
take that
talking about.
application, say, as
I-
to this
I don't think that the
criteria, and
state
read what they put on
regulations
the
preempt
application. You know, so it's
The
not like they
Corps of
have to make
Engineers
up stuff. I
jurisdiction
mean, it's-
generally.
that's why they're writing it down to say this
Because
is
I'm
what.
dealing with a property
Well,
line.
I'm-
it's
I'm-
not-
I'm
it's
just
not
saying, you know,
a
when he said
waterway
can be
that would
accepted,
fit the,
I mean,
the
that could be
exemption
their
that the state's
testimony,
created
and
for
if they're the
trimming of
contractor,
roads that
and
affect
if they're.
navigation or affect your home or use your
Well,
dock.
yeah, on their part, like, on
So
the
the court does have
applications,
jurisdiction on private land.
the answers to those 6 criteria are
But
one word.
I would think that with respect to the area
That's one thing we need to tell
of the artificial waterways, that as it relates to mangroves, that the state would have the primary jurisdiction.
And I know it to the board, it can seem like, wow, this is
I
really
can't give you a
different.
definitive answer on
It's all
that,
to
but that's
make your
that's
job
my,
easier, so
yeah,
you're
that's
not
my
sitting up there.
understanding.
I can't get the Corps of Engineers to give me a
You're
specific,
waiting to make a decision.
something specific that says that they have
Yeah, and you can
jurisdiction to
say
do this.
no
So you
because
give
of
me
this,
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 well,
and this.
National Marine Fisheries overlaid the harbor and that included the canal system, and therefore, it applies to the
Yeah,
canal system.
no, I wouldn't buy
The
that.
whole notion of oversight on the town has driven a lot of what we've done, but so also has.
Because if that was the case, then
uh,
all of
to
the
neighbors'
delegation
lines. Have you
that
talked to
the
neighbors?
Corps gave
That
the
sounds
state
like,
over.
even though that's,
Duck
because we're trying
Well,
to create harmony.
would still
here's
have to go to
something.
Corps of Engineers.
But under the current, like they
But I
said,
can-
the boards come back with a recommendation and say,
Because the
we
intent
want a
was that the
second
Corps of
criteria.
Engineers wanted
And
to
this
take
is
themselves
what
out
we
of a
want
lot
to
of
be
the.
able to consider.
letters of no
Correct.
Well, it doesn't help us today.
A certain
No,
amount of
but
fact-
you can ask for that stuff,
But that's
or,
a quick one, right?
again, you
I
can
don't,
ask
I don't
them,
have a definitive
you
answer,
know,
I'm
if you
sorry.
come up with
Well,
some,
and
that's
honestly,
difficult
we
because
haven't had
city
much luck
application,
with it.
anytime, you know,
This
So,
company
it-
down in
you know,
Fort Myers, we're taking
causing you
the
problems
easy way out of
because-
this now. Rather than me applying for a permit through the Corps of Engineers and National Marine Fisheries, which I've done before, and then have to pay mitigation fees to Little Pine
yeah, so
Island.
you would go to them and say,
What
as a board,
I'm doing now is I'm taking the property owner and
we
saying,
would like,
contact these guys.
Yeah.
They'll, they have no problems with it at all, so for me, that takes me out of the
Yeah, sure.
permits and
Yeah.
let them be, but it's still the property owner that's gonna be on the hook if some reason the Corps comes back and says, you took them out and we're gonna fine you
that's what he's
for,
saying, if they made that
removing
a
them.
condition,
So, but I
whatever that
think
is.
the probability of that happening
Typically
is
when it's,
pretty, pretty low.
Well, do you know the name of the company you're referring, that,
for a piece of property.
No,
That special
I presume it's a matter of environmental consulting firm of some sort.
it is, and, there, it's called IMC or something like that. I can get you the,
An affidavit like that would be a way, that it is in there, so someone
Forward
purchasing the property
information.
would come up on
Maybe
the
they got
tax
something on
sale.
their website that
Say,
would suggest
they
how, you know, what they're
special
talking
permit.
about.
So, you know, maybe that's something we talk to David about, should these be recorded?
yeah, I got it back in my office, but,
Have this
okay.
person, this property has a
I
special
will,
permit, and if these things happen,
sent
you
to, actually, I'm
don't
gonna talk to them today, cause I'm really,
build to what
right, it
it
takes
says.
18 months to get
You know what I'm
a
saying?
permit from the Corps of Engineers, and they're so freaking bureaucratic. It's not- Every time I do it, I've done like 10 of them. Every one of them, I gotta do it different. They want a different requirement.
That's why, to the extent that you can fit it into one of those nationwide permits or whatever, that's
No,
just
and
an
just
added
put on
process.
the permit when they
But,
build,
but they keep finding ways to make themselves part of the process, that you can't, you know, you can't avoid it, but,
This is a very good presentation. This is very helpful to us.
well, cause I
Well,
can tell you before.
It's not only helpful to us in the committees, but I have kind of